well, since 9 o'clock, as scheduled by the judge, we didn't see the face of the Attorney General. Other cases were being adjourned. We were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, he won't grant us the adjournment and that he is ready to continue the case. As to why the judge is in an ambulance route to continue the case and cannot wait for the Supreme Court for 1 week. The list match to be designed. And I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. And then, I leave him to do what he wants to do best. That's why I've left the court.
Ebusuya for netie for ni de kwan so me patcho me ma obi bia akwa ba eba channel so han me daily update TV. Ebusuya me patcho video na ye kwa share no, that is an introductory video to enkomo aye ba bedi. Na in the video no yet say lawyer Akyea give justification as to the reason tia or no e walk out of court no or walk out of menka say judge ana no tia asem so no. I mean vis-a-vis Edubuahin Kesi. Lawyer Akyea ona oye Edubuahin ne lawyer ne lead counsel. Into omo call court no ana o raise objections bi na lawyer ne say na me patcho before that nkwa na ne objections ni na ne say omno na nya new update bi opese o de kan asem no ho na lawyer no adjourn court no led by the judge and the presiding judge no on adjourn case no and a judge no so there be into judge no decline Akyea lawyer Akyea on no request no and Akyea say any here say we decline me the end me so cry me free court cry say court no say o dia I know Anna or walk out of the judge of free court on cry no me patcho bro free court one and or na because a journalist say interview na all my justification as to the entire Otimie day walk out of court no and I said the presiding judge and na me patcho sanse mo nyina ba ye nkofo bebre apia babontin aba react to na me patcho nipa ba ko no so lawyer Penny Kesi a owo oman mu a ye ka great lawyers na yentimi nyina mfrim lawyer Oliver Bakavama wo ono so apia babontin de na no abetu asemi na me patcho eno na eda screen so no say ye kan insem na ansa ye be kan insem na nkasa no in all no de all patcho ne say enti lawyer Akyea party me and walk out of a judge court no Anna the judge also represents the court which is the judiciary lawyer Akyea and kasa no kan ho no lawyer Akyea walk out of the court and I said the judge ama ebasa and the judge in current man citing for contempt and I said even the Ghana and I said the legal counsel the general legal counsel no so ent me am friend no and bisa questions there ade Akyea no oye ni person obi ana nti in all no o hwe nsema Oliver Bakavama wo kana o kire say e was so almost citing for contempt because adia Akyea lawyer Akyea ye no odi wana say wan fa obuo amma court no amma the presiding judge and of which a contempt of court because nanka ye any make us obi fufro lawyer fufro nanka okoye sade we ya maybe kura nanka ya citing for contempt adentina judge no wo make a request na judge na decline wo request a on ma judge no enwie na monko na wo de wo ya wo say because say oni decline and I say judge decline wo request ni ntino we dwane free court on contempt and that is what lawyer Oliver Bakavama o eka I will say on the or chiremu say omon citing for contempt and I say the general legal counsel omon friend lawyer Akyea na omon bisabisa no questions na ade na oye no asotwe bia wo bi omon fa man because wan fa obu ama court no wan fa obu ama the presiding judge no and of which I agree with Nsema Oliver Bakavama o eka ebusu ame patch of our comment share comment section honum na ye beje na ya kenkan said the makan can media many Oliver adwen papa many Oliver adwen say or call it for say or mobile site lawyer Atta for contempt of court and now say the Ghana General Legal Counsel no ebe freno now we maybe say some questions na asotwe bia wo bia no na omo dia ma no omo mfa no because one fa obuo amma the presiding judge and I say court no all just because who feel say the judge was biased. Even if the judge was biased, Krana said your work na I didn't know one train, I'm a judge in a baby, I'm a wanko. I said, oh, the one for Ubu, I'm a judge. No, in Zebusia, me patro Makasa Kakra said, Makan for comment section. Yanko in extensive manner the full details of lawyer Atta ni mekase ne action now, yeah, no, Yanko tie Mwankasa, Yanko Puncha in an own yakes, and I bidding comment,
who is out of the court, a walkout of the court premises. Their reason: the trial judge refused to grant their plea for adjournment. The court had been scheduled to hear the testimony of the prosecution's second witness on Thursday, the 23rd of October. Lead counsel Samuel Atta notified the court of filing an application of the Supreme Court to prohibit Justice Eugene Nyadu Nyante from further hearing the case, citing bias. He prayed for an adjournment of the case pending the determination of the matter at the Apex Court. But prosecution, led by Principal State Attorney Esi Denta Yanka, urged that the court dismiss the application. We'll tell you or bring you the thought and position of Atta, who is lead counsel for the man in question, or the director of the former director of the National Signals Bureau. Before that, let's speak to our court correspondent, Lord Eduasari, who has joined us on phone. Lord, thank you for your time. So tell us exactly why the Atta-led legal team thought that their position was not being agreed with by the judge. For that reason, they walked out. Why?
Right, Martin. So, Samuel Atta today, even before the business of the day could continue, notify the court that there had been new developments in that they had filed an application for prohibition at the Supreme Court. Now, this application is basically meant to prohibit the presiding judge who has been hearing the matter, Justice Eugene Nyadu Nyante, from continuing to hear the case. Now, their reason was that he has been biased towards them since the hearing of the case. Now, after notifying the court about this application, he prayed for, he cited some authorities and indicated that because of the kind of application that he had filed at the Supreme Court, it meant that automatically there should be a stay of proceedings and then an adjournment. But then the Principal State Attorney, or the prosecution led by Principal State Attorney Esi Denta, rebutted and opposed this submission. He indicated that the mere fact that an application of this matter had been filed at the Supreme Court does not warrant an automatic adjournment. Now, she indicated that this trial particularly is a criminal trial, and the authorities that lawyer Atta had cited had to do with another matter altogether, and so they can't be lumped together for this. But Atta still maintained on that stance. Now, in the end, the presiding judge sided with the prosecution and held that the fact that an application like this is pending at the Supreme Court, it didn't warrant an adjournment in the matter. And so he dismissed that adjournment and then proceeded to call the prosecution's second witness, which, who is the Director of Finance at the National Signals Bureau, who was supposed to give her evidence in chief. Now, Martin, a bit of background to this. At the last adjourned date, the Director of Finance at the National Signals Bureau submitted some receipts during her evidence in chief. Now, these receipts had to do with the expenditure that Kwame Dubois, during his tenure as the National Signals Bureau Director, expended, really. So, Atta objected to that list of transactions or receipts which was going to be tendered, in indication that they were prejudicial, and the fact that it had to do with the National Signals Bureau, it meant that it would affect the security of the country, for which reason he wanted those documents not to be turned into as evidence. And then the prosecution, then led by the Deputy Attorney General, who, by the way, today in court was absent, indicated that it is not in the place of a private citizen to indicate which documentation in court is prejudicial or will affect the security of the nation. That mandate or power lies in the bosom of the executive and, by extension, the government. And then the judge agreed with that. And so that objection was overruled. And then the matter continued. This is one of such instances that Lawyer Atta has been relying on, indicating that since the case began, there's a term that he likes to use. He says the judge is on an ambulance mode. He just wants the case to be expedited and moved on at the detriment of his clients without them necessarily making the case. And so he went to the Supreme Court to file an application to prohibit the justice or the judge to continue to hear this matter. He spoke to us after this. He was still not pleased about the entire thing. But Martin, even after this was done, because he walked out of the court premises, the accused persons, Kwabena Dubois and his spouse, Angela J. Boateng, they were still in court. And because the matter had been dismissed and then the hearing was continuing, meaning that the second accused was going to continue with the testimony, the judge ordered the accused persons, Kwabena Dubois, to defend him, to call his lawyer back, or meant that you stand on his own as his own lawyer. Now, at that point, the court went on a brief recess, and when they came back, Kwabena Dubois indicated that indeed he hadn't been able to establish contact with his lawyer, and pleaded with the court that he wouldn't be able to, as it were, defend himself or represent himself, and so prayed for leniency and an adjournment, to which the court obliged and the justice or the judge gave the adjournment. And so the case has been adjourned to October 30, Martin, for the continuation of this matter.
Right, Lord, thank you for that update. Let's now listen to Akyea, who is lawyer for the former Signals Bureau Director, Kwabena Dubois.
In the court since 9 o'clock, as scheduled by the judge, we didn't see the face of the Attorney General. Other cases were being adjourned. We were waiting until all the cases were clear, giving an impression that, look, this case is what matters to the judge the most. Now, yesterday, I filed a motion for prohibition in the Supreme Court, saying that we are not comfortable that this judge will give us justice. I brought it to the attention of the judge. I also raised an issue that we should adjourn the case and abide the outcome of the application to the Supreme Court. The case is just next week in the Supreme Court. The judge is saying no, he won't grant us the adjournment, and that he is ready to continue the case. As to why the judge is in an ambulance to continue the case and cannot wait for the Supreme Court for 1 week, the list match to be designed. And I'm caught between the rock and the hard place. How? The ambivalence that you want to disqualify a judge from hearing the case and you sitting to continue the case. I cannot answer in the Supreme Court, so I need to leave the chamber. And then, I mean, leave him to do what he wants to do best. That's why I've left the court.
Are your clients not going to be?
Well, my client is there. I know he can't do any legal work for himself, but they should be glad that the lawyers are saying that they can't continue with the case. They could have also gone out of the court, but they are accused persons. Because they agree with me. But because they are accused persons, they can't get out of the court. That's why they are there. Because they are accused, but not that they endorse what the judge did.
If you go to the Supreme Court, we are not preempting, and the Supreme Court sends you back to the High Court, how will your approach be?
Well, let's leave it to the Supreme Court. I don't want to play clairvoyance, but I think we have a good case for the Supreme Court to consider. That's what we are doing. We don't know what the Supreme Court will do, and you don't want to play lottery with this very sensitive case.
But Counsel, regarding the decision by the judge, he cited two conflicting authorities and decisions by the Supreme Court, for which reason he used his discretion to refuse your application. How does that come to you, seeing that you chose to walk out when really he used discretion?
What discretion is on this matter in which there is an old authority, the Supreme Court has departed from the authority, and the Supreme Court in 2020 is asserting that when there is a pending application for prohibition, and the lawyer tells the judge looking after the affairs of the case that look, adjourn the case and let's wait for the Supreme Court to determine the matter. And if the judge should not do that, it implies that the judge is biased. If you see the Supreme Court decision and you don't want to respect it, I can't force him to obey the Supreme Court, which is at the summit of the justice delivery system. But I think we'll have a day in the Supreme Court.
Okay.
And so that is Atta, who is lawyer for the former National Signals Bureau director there. And the news is that they walked out of court today because they were asking for an adjournment, specifically because they thought that new evidence that had been tendered in was not in favor of the case that they were defending. And so when the judge declined, they decided to walk out, leaving the suspect alone before the judge. And, you know, the suspect said that he could not defend himself. So the judge asked that he call his lawyer to come in and defend him. He says he's tried several times. He could not reach his lawyer or his legal counsel. So based on that, the judge decided to adjourn the case. So we'll definitely update you as to when the case will be recalled and see how it plays out. This is still 3FM.
Abusu ame pacho me do bibia se when yamre no abenya video ni bi so ahwe said am kan no ahanum daily update TV obo kwan so nya video no hweye no say wani je ho kwa de my thumb up, subscribe to our YouTube channel no, na share our videos so ma we love say nya bi enti na e ma remfi say notification bell no be boss so and also ye ne say maybe I the latest ni be ba on board YouTube be ma special invite obabon kai no anya akwanya na wabenya videos ni mi so ahwe nyakopo nhia ye nyina na onye Kesi na me pacho video I brem credit to 3FM na yenya other parts of the video na ye kika see ni aye so ye de abrem no ti nyakopo nhia obibia na onye obibia Kesi na me pacho fa comment share comment section on me beje na ya kenkan one ensema anase asema lawyer Oliver Barker Vama wo epia babonti abekan one ne ya adwena na ase one ne nya adwen said the mechanic and me dear menene ya adwene na me huni say lawyer Atta wa fa obuo amma court no nti no sene na ka ekoye obi foforo anka court ni be citing for contempt and I said the Ghana General Legal Council ebe friend no omunye the same to lawyer Atta because you see equality before the law. Equality before the law. The law isn't a respecter of persons. So be bia emrani benya obia no. Emrani no be di pepe penti san etie dia. And then lawyer Atta and say no ye no wanye ni year of which oko court kra na say judge ne ba. Amka court rise na obia sorry. So court no ewie bibia kra na lawyer no and I said the presiding judge no has to leave even before Christ say the lawyers and other inconform mu nyina so de ebekwa abontin eno ne kire obu a ye woma ye judges no na ade ntina wa raise up your friends and a request wa raise a point be wa make a request no say there be me declining wa say me dem ma work it out of and as ma work it out of you enye fair one for obu ama judge of which a contempt of court. Na ebusuya makasa kakra fa comment share comment section e be gene akenka me do bibia